Today we have the honor of hosting Professor Yuval Shany, a noted Israeli human rights expert and professor at the Hebrew University. He will give his lecture on legal and constitutional issues relating to the use of digital surveillance in Israel to combat COVID-19. Professor Shany is an expert on humanitarian law and human rights. In 2018, he was elected chair of the United Nations Human Rights Committee, a committee of scholars who review complaints of member states with the International Covenant on Civil and Political Rights. He is currently the vice chair of the Human Rights Committee. As of 2018, he is the deputy president of the Israel Democracy Institute. Following the lecture, as usual, you are welcome to ask questions by raising your digital hand. And tomorrow you will receive the recording of the webinar by mail. And the next webinar of this series will be on Sunday at the same time. And now, Professor Shany, the floor is yours.
Thank you, Maura, and good evening, everyone. I mean, I see a lot of very familiar names in the list of attendees, so it's nice to at least acknowledge your presence, the presence of so many good friends and colleagues. So thank you for joining. The topic I'm going to be discussing today, digital surveillance in the context of the Israeli constitutional crisis and political crisis, actually is also related to my work in the university in the Federman Cybersecurity Research Center, which has done a lot of work on digital surveillance as well. I mean, many of you have been following events in Israel, and you know that this has been a very, how to put it mildly, a challenging period. Not only on the health front, where Israel has been experiencing, like many other countries, certainly in Europe and North America, a very serious situation, but will be facing now a very serious economic situation. But all of this has happened in Israel while we were facing also an unprecedented political crisis, which also deteriorated to an unprecedented constitutional crisis. Which made the whole framework, the political, legal, constitutional framework of dealing with COVID-19 an exceptionally difficult one. Add to that the fact that Israel, as you know, has been in a state of emergency already since 1948, which makes its democratic institutions somewhat more vulnerable to deal with situations like this one, or at least already has within the system some features which are not compatible with what you normally find in democracies. So all of these elements really came together around the mid of the month of March, creating for us, lawyers, academics working in Israel on these issues, what you can consider a perfect storm. Let me unpack some of these issues, and we can address in greater specificity some of the points if you wanted the Q&A segment. So as you know, in Israel, the last time Israel had a functioning government was in December 2018, and that was when Netanyahu, the prime minister, called for elections because he lost a majority in the Knesset. And since then, we've had 3 rounds of election. We've had an April election, September election, in March, and throughout these 18 months, we have a government, but this is an interim government that does not enjoy a majority in the Knesset, and also is quite limited constitutionally under normal circumstances in what it can do because it does not have democratic legitimacy. So suddenly this government is confronted with what is one of the most serious public health crisis that we have ever encountered, and is resorting in this context to some very harsh measures. And Israel, as you know, has responded quite quickly and quite effectively, but in ways which are, at least from a legal point of view, quite controversial. So this government, this interim government, has introduced severe restrictions on movement, a very harsh policy of mandatory confinements. More than 150,000 Israelis were issued confinement orders. limits on the operations of businesses, limits on movement, limits on assembly, mandatory hospitalization, and as we will see, also very intrusive surveillance measures, which I will dedicate the second half of my presentation to. So this is already, you have an interim government with limited democratic legitimacy engaging in very severe restrictions. This is already a very combustible combination. Add to that a lot of most of these measures were introduced through emergency legislation. So let me backstep and perhaps explain what is emergency legislation. So we have in Israel a number of laws that do authorize ministers under situations of emergency to issue certain quite dramatic orders. And for instance, we do have a public health ordinance from 1940, which was introduced by the British Mandate in Palestine. And that ordinance does have the authority for the Minister of Health to issue, for instance, movement restrictions in the face of an infectious disease. So this is one framework which raises significant issues, but in a way it's a less troublesome framework because it is already built on existing legislation. But then you also have under our basic law, which is our version of a constitution, the government in a situation of emergency can pass new emergency legislation, which overrides existing legislation. So what the government actually did was in the middle of March, they started passing emergency legislation, which overrides ordinary legislation. So you have a situation where the government, which is again, a government that does not have a political majority, is in a way concentrating in its hands both executive powers, but also legislative powers, and it is introducing criminal law instead of parliament. So this is already a very serious deterioration from a democratic point of view, and I'm putting aside for the time being whether this was justified or not. But in terms of the structure was suddenly put under a lot of pressure. Now, add to that another dimension. So as you will see, we are, and this is why we were talking of a perfect storm, because, okay, under our basic law, the government can introduce emergency legislation, which would override ordinary statute. But that emergency legislation is subject to two very important sets of controls. So these are, so even in state of emergency, we have a system of checks and balances. And these checks and balances are essentially parliamentary supervision and the judicial review. So what you have in such a situation is you have the emergency regulation is put before the Knesset. And if the Knesset is unhappy with this emergency regulation, they can basically pass a motion to suspend the emergency legislation. They can also substitute it by ordinary legislation. They also monitor the implementation of emergency legislation. So this is actually a very important set of safeguards. And on top of that, I mean, if a person believes that the emergency regulations are abusive or unlawful or violate constitutional principles, they can go to the court. So this is, in a way, these are some of the safeguards we have to mitigate the democratic aberration, which is the government legislating. But what happens in mid-March, which makes it all more difficult, is that this is really when the old parliament, the 22nd parliament, has expired. Because this, after the March election, the new parliament, 2 weeks after the election, the old parliament expired. The new parliament was convened. And the emergency regulation was introduced really at the seam line between these two parliaments. So you have regulation, which is put forward, but there is really no one in parliament to actually monitor this and take the measures necessary What's more, we have in the same week when the regulation is passed, we have this tug of war between the old coalition and what seemed at the time the new coalition, which led to the outgoing chair, the Speaker of Parliament, to suspend the operation of Parliament until some political compromise is reached on the composition of the different Knesset committees. He also refused to resign. So in the midst of all of this, we also have a constitutional crisis surrounding the restructuring of the new parliament. And this is in time where we do need this parliamentary supervision more than ever before. Add to that the fact that on 15 March, the same night in which the emergency regulation was passed, we also have a decree issued by the Minister of Justice, which is suspending the operation of the courts because of COVID-19 public health related measures. So accessing the court, at least initially, it was believed that it would be difficult to access the court under these circumstances, which eventually this was proven not correct. I mean, there were still, the Supreme Court continued functioning throughout, but this was, I mean, for people who were observing Israel democracy from within and outside, this seemed like a very dangerous moment in time. And a government without political majority is taking extreme measures. It is using, as you will see, the Secret Service to spy on its own citizens as part of these measures. And this happens without parliamentary review and with what appears to be very limited judicial review. So the whole discussion about responses and surveillance and privacy in the context of coronavirus in Israel was happening within the context of a very serious political and constitutional crisis. Now, what I should say that since then, I mean, a month has passed since that fateful week, and at this point in time, we are in a much better situation. Political and legal situation, in the sense that Parliament, the crisis over the composition of the Parliament committees has been resolved. The Speaker has resigned, and now we have an interim Speaker instead. So Parliament has resumed monitoring the exercise of government powers. Also, the Attorney General has instructed the government to stop using emergency regulation and submit instead ordinary legislation to Knesset on an expedited schedule. Judicial review is exercised. And as you know, we will soon, it looks like soon we will even have a government, which is for us a very exceptional notion. So in terms of the democratic, legal, constitutional framework, it seems like we have pulled ourselves a little bit of the hole we were in a month ago. But still, very serious questions do remain about the whole issue of balancing between individual liberties and human rights and safeguards that appertain to this balancing. And now let me discuss more in depth the question of surveillance, which is perhaps one of the most difficult issues that was raised in terms of this balancing in the recent crisis. So I think it's important to say that everyone agrees. I mean, I don't think there is a single person in Israel who's working on these issues who believes that there should be no balancing, namely that in a situation of public health crisis, which generates a very serious threat to the lives of people, to the economy, that the government shouldn't take measures and that they shouldn't limit the full enjoyment of human rights. So this is not the question. The question is really, how do you balance between the very strong public interest on the one hand and the and individual liberties? And in our legal system, this is usually called a question of proportionality. How do you introduce measures which have sufficient safeguards and do not exceed in terms of the limits they impose on human rights and civil liberties? They do not go further than what is actually necessary with response for the crisis, because of the crisis. And eventually there would be some cost-benefit analysis types of questions. So let me talk about specifically the issue of privacy, because this is, I think, where the most difficult, some of the most difficult and probably legally sophisticated issues were raised. So what is the privacy related issue? So the strategy that Israel has introduced in order to deal with the COVID-19 crisis was a combination of very stringent movement restrictions. So we had confinements, we had limits on movement in public space, we had a general lockdown, we had very stringent social distancing practices. And these, as those of you who are following the situation in Israel, this appeared to be quite effective in flattening the curve of infections and patients in serious conditions and even of death. It did come in a very at a very high economic cost. And now, earlier this week, we have now basically switched to the next stage, which is the gradual loosening of restrictions and a return to what is called the new corona normal. Of course, the concern here is that upon return to normalcy, we will see a resumption or a renewed eruption of infections. So this is like a very gradual return to normalcy. Now, at both stages, both at the containment stage and now at the return to normalcy, there is, of course, the strategy in a way is quite similar. So for the government, what is critical is to identify as soon as possible infected individuals and those who have come in close contact with those infected individuals, and confine those individuals and those who came into contact with them as soon as possible. So in order to achieve this, this strategy, both the identification and also the enforcement of confinement, government resorted both to law enforcement in order to aid it in enforcing the confinement and also in aiding it in investigating the infection paths. And it also resorted to technology, to digital new technologies, digital technologies, in order to assist law enforcement and the Ministry of Health in both contexts to investigate infection paths and to enforce confinement orders. Now, they did it through two sets of legal measures, which I will now describe. One measure or one set of measures had to do with authorizing the police to resort to metadata, which is essentially, for our purposes, information that is obtained from the cellular companies about the geo-positioning of cell phones, so as to allow the police to identify or to enforce the confinement, in the sense that they will know whether someone who should be confined to a certain address is moving around the country and either infecting other people or putting other people at risk. So for this, they have passed emergency legislation that amended an existing law, a 2007 metadata law, that does authorize the Israeli police to obtain metadata in the context of serious criminal investigations, and also in the context of preventing threats to life. So essentially, the police already had this authority. So why do you need a new law to basically reauthorize them? The answer is you need a new law to reauthorize them, because under existing legislation, they need a judicial warrant every time they seek metadata. And here, the emergency regulation absolved the police from obtaining metadata, obtaining judicial orders. So they basically could at any time go to the cellular companies and ask for information about persons that they know are supposed to be in confinement. In order to make the system a little bit more proportionate in our system. In our legal system, the government did provide in the regulation that the police would not systematically monitor everyone, but they will conduct some random checks. They have so far conducted about 6,000 random checks. And they have discovered, according to these random checks, about 800 cases where individuals were not in the place where they were supposed to be. Now, this regulation has been challenged in court. Civil society groups have brought a challenge against this regulation to court. They basically said this is an excessive measure. The police can engage in home inspections, surprise home inspections, or they can call landlines. They don't need to engage in surveillance. There is no proper monitoring of what they're doing. If they want to get metadata, they should go to a judge. There was no reason here. I mean, the cost-benefit analysis is such that the dividend is quite small. Actually, it was discovered today in the Knesset hearings, which I will say something momentarily, that there have been only less than 5 cases in which the police have identified people who are infected, who were moving around. So the whole necessity for taking such a measure, which does infringe on personal privacy, does basically engage in surveillance on people who have committed no crime. This has been excessive. So the challenge was brought to the court. On March 16, the legislation was passed, entered into force. On March 19, the court suspended it from going into effect. On March 24, we had back again a Knesset committee that authorized the continuation of the measures, but introduced a sunset clause, which expires actually tonight. They have instructed the government that if they want to renew the legislation, they would need now to submit proper legislation. The government this week has tried to pass new legislation in Knesset, but members of the Knesset were very critical. And actually today, the government announced that it is pulling back the bill. So for the time being, there will be no police surveillance because there was a sense that the balancing here was improper. The second bill, or the second track, which is even more controversial, has to do with the ISA surveillance. Okay, so ISA is Israel's security agency, what sometimes is referred to as the Shabak or the Shin Bet. So this is the Secret Service. And the Secret Service, unlike the police, they essentially have their own databases. They have their own arrangements with the cellular companies. They don't need a warrant. So they basically collect a lot of information. And here what the government, and they use it, of course, for very specific reasons, namely for counterterrorism reasons. But here, the government actually passed, again, emergency regulation, which instructed the ISA, the security agency, to assist the Ministry of Health in conducting epidemiological investigations of people who were already infected. So how does it go? The ISA is able to, it basically has access, or it can get access to all relevant metadata, which relates to geopositioning. So they can basically get information about reception areas. So when we move from one reception area to another reception area, they can locate us. And they can also access GPS information, which our telephones are communicating with satellite stations. And on that basis, they can basically retrace back in time, and they were instructed to retrace 2 weeks back in time, the infection path, namely the exact physical locations in which everyone who has been infected by corona has gone through, but also the potential infection tracks of everyone, every Israeli citizen who may have come in close contact with these individuals. So the idea is that the ISA is able to obtain names from the Ministry of Health of people who were diagnosed as corona patients, and then return to the Ministry of Health with the names, ID numbers, addresses, and cell phone numbers of everyone who may have been in close proximity to these individuals. And then the Ministry of Health would issue a quarantine order for those individuals. We know that there have been about 4,000 individuals who have received quarantine orders on the basis of these epidemiological investigations. Now, this is a very controversial measure, partly because of its privacy implications. Again, you have the ISA tracking down individuals who have not committed a crime. Those individuals are tracked also with respect to a period in which they were not under any quarantine instructions. So they were actually moving around legitimately. So there is no law enforcement element here. And of course, this information that the ISA is collecting is a very sensitive, potentially a very sensitive and private information. So this is one set of concerns about this measure. And again, there are questions about its cost effectiveness. But I think what was even more scary here is the idea of slippery slope. I mean, you basically take a spy agency that has honed very sophisticated data collection and data analysis tools in a counterterrorism context, and you basically set it loose on the Israeli population. And this is, in terms of mission creep, a very serious development. And many people in Israel thought that this actually sets a very bad precedent. I should say that the ISA itself has had very serious reservations about this move. Now, I do not want to continue for much longer because I'm curious to hear your questions. Let me give you a state of play of where we are at currently with this ISA regulation, and then say something about what other countries in similar situations have been doing, and then we will wrap up. So in terms of the ISA regulations, the ISA regulations have been initially adopted for 30 days, for 2 weeks. They were then extended by the parliamentary committee that is now monitoring their application until the end of April. We do have a court challenge, so the matter is now before the Supreme Court, and the court last week has had a hearing on this case. This was for us also an historical hearing because this was the first time that the court allowed the hearing to be broadcast on live, accepting the claim that in an era of Corona, the interest of public accessibility to the judiciary, the fact of that the proceedings are open, it has to be implemented through online broadcast. So this is an important development. The court, in the questioning that the judges posed to the state attorney's office, I mean, they expressed many reservations about the system. They were concerned about whether the ISA has the legal authority to operate in this field. I mean, it's an agency that was created to promote national security. The court had reservations or had questions as to how broad this idea of national security is going to be. The court also had a lot of questions about how long will this take? I mean, is this going to be a permanent fixture? I mean, the state has asked only for a 30-day extension, but it was cleared from the discussion that we will need this information even 30 days down the line. And for the state actually having the ISA, providing it the information, releases it from the burden of developing something which is long-term and sustainable and perhaps more privacy-oriented. And the court also had questions as to why Israel doesn't go in the path of other countries who have developed apps, voluntary apps for essentially performing the same tasks. So let me say two sentences about these apps. So in countries, for instance, like Singapore or South Korea, individuals are encouraged, well, some say very strongly encouraged, to download apps on their cell phones And those apps enable, in the event that they are being traced as infected, or in case that they were in close proximity to someone who was infected because there has been a match between their Bluetooth capacity, their Bluetooth functions. Under these conditions, the voluntary app is actually doing the work. It's actually substituting this external surveillance system. Now, Israel does have an app. It's called the Protector app, Magen, Applicaziat Magen, that the Ministry of Health developed, which does engage. It's not about Bluetooth contact tracing. It's really about path tracing. So the same information that the ISA collect, I mean, under the app, everyone collects on its own phone. But in terms of privacy, it's a much better system because all the information is only stored on your personal phone. And if the Ministry of Health is identifying an infected app user, it is downloading the infected user's path on your own phone, and you can see whether there is a match. So in theory, this is a much better system of providing epidemiological information without violating privacy, both because it's voluntary and second, because there is no external database. But the state says, look, I mean, because it is voluntary, the number of people who are using the system is going to be very limited. We have about 1 million people who have downloaded the system. The population is more than 8 million people. So they think that this is not going to provide an answer. The court did ask them, what did you do in order to encourage downloads? And the answer is, we have done something, but maybe the fact that they have the ISA is for them an easy substitute. So let me summarize, and then I see some questions already posed. Let me summarize, and then we'll open it up for questions. So where does Israel stand in terms of the health situation? I think the health situation, many people in Israel feel that we have basically have gone through the worst stage of the crisis. The numbers of, there was a lot of concern whether there will be sufficient respirators, but eventually we never even reached the 10% mark, namely that there was no need to even to use 90% of the respirators. So in terms of the curve has been flattened, and now we are in the return to normalcy stage. In terms of how did we do in terms of protecting liberty, in upholding democratic institutions, and also in terms of preserving the economy, I think here the jury is out, and I think there is much to be said about the measures that have been taken. I think many of the features that we are seeing now have more general, I think they have more general relevance. As I said before, when I started, Israel is a country in a perpetual is in a perpetual state of emergency. And when you are in a perpetual state of emergency, you in a way get addicted to the state of emergency. It's not only a dire situation, it's also an opportunity at some level for the government to make shortcuts. And I'm afraid that in this crisis, we have seen an emergency built upon an emergency and a propensity to utilize shortcuts, which one maybe could have justified in the very first days of the crisis, but going forward, and now that you have the democratic institutions back in place, and whether you can conduct a more level-headed cost-benefit analysis, I think going forward, the emergency powers would have to be as rapidly as possible replaced with more regular checks and balances. So I think I will stop here, and I will now be happy to take questions. I'm wondering whether Mara is still with us. Yes, because you were frozen. So for the duration of my talk, you were frozen. So I was wondering whether I'm speaking in space, but now I see that you are.
Okay. I am here. So we have the first two questions from the chat, but I would suggest everybody to raise your digital hand. It will be much more better, but we can begin from the question of Julian. And she's asking if it's possible to have some clarification on how was the collaboration on or communication between countries to adapt measures. Many of the measures were global, and understanding them would prevent the onset of so many conspiracy theories we are hearing today.
Well, thanks, Julian. Yeah, I mean, in terms of unofficial communication, there has been a lot of unofficial communication. I know that Israel has been in close contact with many countries around the world, exchanging information, scientific information, exchanging also information about availability of medical equipment. There have been shipments from other countries. Israel also shipped some equipment overseas. Has there been great collaboration in terms of harmonizing the very containment measures? I doubt it. I think we have seen, at least in the initial stage, many states go it alone in terms of canceling air connections, taking very radical measures when other countries are not taking these measures. So in terms of harmonization, I think much is left to be desired. And I don't think this was the finest hours of international cooperation or of the World Health Organization, for that matter, that was supposed to perhaps be more dominant in facilitating this. Still, I mean, the conspiracy theories, I mean, I don't buy them, but I think they will continue flourishing as long as you have something of this magnitude, which is not completely comprehended by individuals. I see Maria, maybe I'll read another chat question which I see. Can you elaborate on why the government did not issue a new regulation on police surveillance? Because the Attorney General instructed the government that now that Parliament is functioning, they do not have the legal authority to issue emergency regulations. So they have to basically go through the Parliament at this point in time. You can only use, I mean, the logic of resorting to emergency regulation is that you have to act in great speed, and you do not have time to actually convene the Parliament and go through the nuts and bolts of legislation. But when Parliament is functioning, the government has lost the power, and they know that if they will pass emergency legislation, the court would strike it down, as it actually did. I mean, it initially suspended it because it thought that a measure of this type, and especially the police measure, which the utility of which is quite questionable anyway, to go for this radical step with emergency regulation, which simply would not pass the constitutional review at this point in time.
Okay, so let's wait for the next questions. Again,
there are also some Q&A questions.
Yeah. Okay, from Giorgio Gomel. Okay, so my name is Giorgio Gomel from Italy. You know, the pandemics here is very serious. Only lately we are discussing whether to introduce an app for contact tracing which would be voluntary and anonymous. Is the app used in Israel on voluntary basis?
Yeah, so the app we have is voluntary and anonymous. I mean, as I said, we have the Ministry of Health app is excellent, and it does meet privacy requirements, and it is voluntary. The problem is that the app is used only as a belt and suspender over the ISA system, which is not voluntary and it is anonymous in the sense that the ISA is subject to very strict rules on not disclosing this data, but both the Ministry of Health is obtaining data, and also the ISA is obtaining data, which is personal data, namely where the identity of people and where they were in the last 2 weeks, every specific place they were at. So I wouldn't say that Israel is doing a great job in terms of protecting privacy in this regard. I think it's actually taking, among democracies, it is taking the most extreme measure. Of course, the situation in Italy is very serious. And in a way, you could say that, people in government might have said that had Israel not taken such extreme measures, we would have been in a much worse situation, which is an argument that is very hard to test empirically. Yeah. So maybe I'll stop it. What I do want to say about the ISA, I didn't have time to say that, but there's also some questions about how accurate it is. So it's not I don't want to present it. So on the one hand, it's it is covering the entire population, but there have been a lot of reports that it is also quite inaccurate, and that people who were actually going out of the way not to stand in proximity to other people. For instance, they were speaking across the street with family relatives, so as not to violate. They were still caught by the app as if they were in close proximity. So there are questions as to how accurate this really is, which in a way raises questions as to how accurate is the system that the ISA is using also in counterterrorism context, which is probably why the ISA was not so happy to begin with to have this technology being now exposed in the open. So it's also raising questions about what it is doing in other contexts. I see there's a question by Keith.
Exactly, yeah. So to what extent did the opposition parties express concern about the moves taken? Did Blue and White, Kahol Lavan, express concerns in the course of the coalition discussions? How will the new coalition view decisions taken to date?
Yeah, so I think that this was not this so far was not a huge political issue in Israel. I mean, there was a lot of pushback by civil society, but once parliament started assembling again, we did see I think people in opposition, and initially Blue and White were in the opposition, the Gantz faction, and they were actually exercising significant review of this. And the chair of the committee that today buried the police metadata regulation is Gabi Ashkenazi, who is one of the leaders of Blue and White. And he actually, throughout the hearings, he was very critical, and he was chief of staff. So this guy is not a human rights activist in his background. I mean, he was is a major security figure, and he thought that this has really had a very modest security justification. This played absolutely no role as far as we know in the political negotiations. I think there is a strong sense that this is something which is driven. The politics of the matter are really driven within government, between, on the one hand, the Ministry of Health that is pushing for very extreme measures, and other parts of the government, mostly the economic part of the government, which is actually pushing back in order to relax the measures. And in a way, the security measures are viewed as a sort of a compromise, which gives the health ministry some assurance that once they release back the population into the workplace, they will still be able to control the situation. So I wouldn't say that within the political map, this is a huge issue. Within Israeli academia, civil society, there is much more, I think, engagement in this issue, with this issue.
Okay, Nigel is asking, what is the legal basis of enforced 14 days isolation, for example, Israelis returning as well as non-Israelis?
Okay, so the authority is this 1940, Nigel, so this is something we inherited from you, the British, okay? In 1940, the public health ordinance, and it authorizes, in the event of a major infectious disease, the Minister of Health can issue movement restrictions, and on basis of that authority, all the quarantine orders were issued, including for everyone coming back. It's a very interesting question whether businesses could compel workers to use the voluntary app. So far, this has not been raised in Israel, partly because the app is now viewed only as a safety net, but not as the real thing. The real thing is the ISA. So there hasn't been so much focus about the app. Once the ISA things disappear, I think this question will really become very prominent. And when I said in places like Singapore and Korea, people were using voluntary apps, there are big questions about how voluntary they were, because there were these sort of pressures on them. They were also backed by other closed circuit television cameras, and in Korea, they were also monitoring the visa statements by individuals. The closest equivalent we currently have is that places of business are required to measure temperature of employees when they enter the workplace, which is also at some level an intrusion of privacy. And this is, so far, has not generated a huge discussion in Israel. So I would imagine that if you have a voluntary app and businesses are strongly encouraging workers to do that, I think this would actually pass muster, yes.
And we have another question from, again, Nigel Miller. Do you have a view on whether a company could compel its own employees? Okay,
No,
so
this I answered.
You answered.
But
so we have another question from Munif. Yeah.
So this is on the Palestinian situation. It's a good question. I mean, here actually, this has been actually a very interesting development. I mean, of course, in terms of the spread of COVID-19, I mean, Israel and Palestine are exactly in the same boat. So Israel actually took very closely collaborated with the Palestinian Authority and even unofficially with the Hamas authorities in Gaza in order to ensure that they have examination kits and that they have protective equipment and respirators. So in terms of international law, certainly with regard to the West Bank, Judea and Samaria, Israel has responsibilities there because it still has overall effective control over the territory. It is required to provide also to allow humanitarian convoys or humanitarian equipment to be introduced into Gaza. There has been some back and forth with regard to Turkish equipment, but in the end, Israel has allowed this. There was a closing of borders, but actually this was an agreed upon closing of borders. So the Palestinian authorities were also interested in the closing of borders so as to help them contain the situation. And in both sides of the border, so to speak, the situation is relatively, when you look comparatively at the world, it's relatively fine, so to speak. There is also an interesting development in Gaza, which is not directly related to the talk, but there are some, as you know, some Israeli missing in actions, and there are some civilians in Gaza, Israeli civilians held hostages, and actually around this crisis, there has been some movement to engage in some humanitarian release of prisoners on both sides so as to protect them from also the infection. There is another question of
from Maria. Yeah. What do we know about the effectiveness of ISA surveillance until now, and how many individuals were affected?
So as I said before, we do have the number of 4,000 people who were identified by the ISA investigations on top of the people who were identified by the Ministry of Health. And they estimated that it allowed them to raise the number by 60%. So before the ISA entered into the picture, what we had was a system by which everyone who was infected was subject to an epidemiological investigation that traced back his or her path in the last 14 days, and over the public media and also on the Ministry of Health webpage, we had the very detailed information. This person on this day, from this hour to that hour, was in this train, and then in that shop, and then in this street. And every individual was supposed to then compare their own route, and on that basis, notify the Ministry of Health whether or not they have crossed paths with the infected individual, and then go into quarantine. Subsequently, they, of course, also for interrogating the individual, they could also get some names of people who were in close contact with. And the involvement of the ISA allegedly produced many more names. Now, I should take these numbers with some grain of salt because, of course, the more the infection rates went up exponentially, there would be, of course, more numbers, and it was also more difficult for people to use the public reports. I mean, when there are 100 patients, it's one thing. When you have 13,000 or 14,000 patients, it's another thing. And the app, which we don't know, I mean, what would the app been forcefully pushed in, maybe it would have delivered some of these numbers. But I think it is beyond question that the ISA did produce did increase the number of names of people who had to go into confinement. I mean, this is beyond question. I think the discussion really in core is whether, in terms of the cost-benefit analysis, the number of people, of course, these 4,000 are not 4,000 patients. There are 4,000 people who were in close proximity with patients, and may be patients, may not be patients. Whether in terms of the added value, this has been worth it in terms of the liberty, the privacy infringement, and also in terms of the precedent of using the Secret Service for this kind of purpose. And the claim is that there are other alternatives could have been better utilized.
Okay, so we have a few more minutes for another questions. So we can wait.
I see there's a question about Passover and why wasn't Israel, above all nations, better prepared to deal? Well, Israel was not in a bad place, and I think the numbers that we are seeing in Israel, which are quite good, do reflect some of the conditions in Israel that make it somewhat more easy to manage the situation than other places. I mean, it's like Italy. So first, I mean, in terms of borders, Israel has essentially one entry point, which is Ben Gurion Airport. So it's in a way more closer to New Zealand in terms of its access control over borders than countries in Europe, which could be accessed from many directions. Secondly, the population is very young, and we know that with this disease, the survival rates among young people are very high. So in terms of many people contracted the disease, but in terms of serious patients, the numbers were very small. And thirdly, we do have an emergency legislation infrastructure already in place. So the country is quite well, it's quite used to working in an emergency mode. So I think these are all strong assets that help Israel basically respond early on quite effectively. I think the criticism that we are seeing is that against the government is mostly that the time that was saved was not wisely spent to develop a smart strategy of returning to the workplace. And now, in a way, the government is not now really on the fly, is developing all sorts of measures which are really announced at the last minute, and we still don't know, I mean, what's going to happen on many fronts, such as education, businesses, culture, what have you. Travel. So there are many, so in terms of the quick response, we were very good. And I think this is very Israeli. We are very well in improvising, but when it comes to actually engaging in more long-term planning, things are not working so well. Okay, so I think that... Maybe I see another question by Joshua. Hi, Joshua. Are Israelis happy with the restrictions? What about the elderly? Are they safer? So I think Israelis were initially very understanding. I wouldn't say happy, but I think they were very understanding. And by and large, the population in Israel was quite obedient. I mean, they were disciplined, and I think people were taking this seriously. With perhaps one major exception, which is the ultra-Orthodox, that initially some of the ultra-Orthodox leadership was dismissive of the situation. They were even, I mean, some rabbis said that according to halacha, this still does not meet the definition of a plague, because you need first three deaths in order to call a plague. So there was a slow response on the ultra-Orthodox front, and now this is of course changed now radically. So I think people were very understanding. I think at this point in time, people are much less understanding, partly because there is a sense that, as I said, we have passed the worst stage, and people are confused about the rationale for a continued lockdown. And there have been also some scandals about people in high office, including the prime minister and president themselves, who were not strictly observing the restrictions on, for instance, celebrating Passover together. Someone noted Passover with family members, and this has also created some pushback and maybe has not helped the discipline to remain high. And some of the measures put in place are really hard to explain. I mean, it's not clear why. People cannot engage in individual sportsmanship, etc. With elderly and vulnerable people, I mean, this is a remaining feature. This is not changing. So people who are elderly and vulnerable are still in this in a virtual lockdown. And now the next, I don't know if the next very difficult point for us on the calendar is that next week is both Independence Day, but also Memorial Day. And there is also, today there actually has been issued a decree that cemeteries will be shut down on Memorial Day. And this is causing a lot of anguish and concern for, especially for families of the bereaved, who basically for them, this is a very meaningful day throughout the year. So I think in terms of, I think like I said before on the shutdown, people were initially supportive and initially obedient, but I think this is changing. And some cynics are saying that part of the reason why we now have a unity government is because there was also a sense among the current government that the level of support that they were enjoying would not hold much longer. So they need to find another way to share the burden. There is a question here. I see, maybe we can take one or two more. Marafine?
Yeah, from Naomi Burke. Have we noticed whether a specific group within society being targeted more?
I mean, in terms of the ISA, we have no information. We have no breakdown in terms of who was targeted more. We know that in terms of the infection rates, as I said before, the ultra-Orthodox have had a high, exceptionally high rate of infection, partly because of the discipline issue, but also because the density. I mean, some of the places like Brak are very condensed places where you have very large families under the same roof. So infection rates are very high in that community. There is another question from Roel. Was the lockdown necessary, considered it violated right? Wouldn't it have been just as effective to not shake hands, wash social distancing? Instead, we violated rights, and this may not have been necessary. So as you know, there is a very robust debate on this issue around the world as to what is the proper model. I mean, there is the Swedish model that is being put forward as a model which is less, which involves a less radical reaction. Pretty much life goes on normal with some limits. And then there are more extreme models which do talk about drastic lockdown. Israel took certainly one of the most extreme responses in the world. And I think it is too soon to tell whether this is, certainly it did stabilize the situation and bought Israel some time, but it may have also prolonged considerably the crisis, both health-wise and also economic-wise. So I think we don't know what's going to happen. One feature which is interesting also for me as a lawyer is the fact that one activity that was exempted from the lockdown are political demonstrations. And I think many of you may have seen the images from Tel Aviv the other day, where there have been, thousands of people went demonstrating against the new government agreement while keeping social distancing, which does show that some activity could be taken on responsibly without. But I think initially, when there was also a lot of uncertainty about infection rates and about the mortality rates, I think there was here a decision to err on the side of caution, which at least in terms of preventing the collapse of the health system, which was the greatest worry, this had been averted. And it's being, at least I think most Israelis still see it as something that was justified.
Thank you. So here, okay.
So when so when will the court rule? I think the court is gonna rule, the hearing ended last week, and the court is going to rule any day. The current regulation is in force until April 30. So I think they still have a few days, but there is already, it will be prolonged. I mean, the assumption is that it will be prolonged according to the decision of the court. I think most observers do not expect the court to strike down the regulation at this point in time, but it's likely that the court would indicate that the state has a narrow window during which it can use this regulation. But on a steady state, they must develop some alternative features. So they may indicate that this could continue for the time being, but that the state must introduce within this would be my guess, that they would not cut it off, but they would actually limit it in time, or insinuate to the state that they will approve it this time, but they cannot guarantee, or they may not approve it next time, that it will be challenged once the regulation is renewed again with a sunset clause.
Okay.
Yeah, I think we've exhausted the audience and the questions.
Okay, so thank you to everybody. Thank you, Professor Shany. It was really interesting. I hope to see you in the next webinar on Sunday at 8 o'clock Israel time, as usual. So thank you to everybody, hoping that this period and all this period will finish soon. Okay.
Okay, bye-bye. Take care and feel everyone keep safe. Bye-bye.